on now, Floyd. We are on. All right. So welcome to the consultation. My name is Christina Jimenez. Oh, wait. Are we on? Yeah, we are on.
Yeah,
okay.
we're on. Yeah, and I'm Josh Floyd.
Awesome. Excellent. Excellent. And every Friday at noon, we come together. Sometimes it's myself and Mr. Floyd. Other times it is other members of our firm. We've had former clients on. And essentially what we do is we just talk through some complex family law issues and or criminal issues, depending on the day. And I'm very clear at the beginning, middle, and end of these sessions that we are not offering legal advice. And so it's extremely important that if ever you find yourself in a situation where you need an attorney for a family law case or for a criminal defense case, that you go out and you consult with one. Because as you'll see, as we're talking through these fact patterns, any one little thing can change our opinion on the entire case and what a judge may do and how a particular person should proceed. So make sure you hire your own lawyer, and you listen to that lawyer. And also make sure that you follow us, please, on Facebook, TikTok, Instagram, LinkedIn, any social media platform that you can think of. We are likely on it. And so make sure that you follow us and also listen to our podcast and subscribe. So with that being said, Floyd, I'm going to let you roll first with the first question. Floyd, I'm going to need you to get it together and unmute. I know it's been a week. It has been a week.
Your untogetherness, if that's a word, is rubbing off on me.
I know. We're good. It'll be okay. Go on.
Should we take two, or we just pick up where we left off here?
Let's just pick up. We're good. Do it.
Okay. How do I have something in my divorce decree enforced? In the divorce decree, we agreed that my ex-husband would take my dog. He owes me money for a home equity loan, and he must pay me a payment for it by the end of each month, or I get the dog back. Wow. Okay. He has failed to make his payment, and I need to know what to do to get my dog.
What?
Not at all where I thought it was going.
I was like, this is going to be like really simple. I got this. I don't even have to look at the question. And then it took a turn.
So the dog's collateral.
That's creative lawyering, dude. Like,
Yeah.
I guess the dog was more important than the house. Is that, yeah.
I'm not sure.
I don't know.
I think James is the expert on our dog cases.
This is a true statement. Where's James? So
Maybe, but
I don't know. Like, how do you enforce this?
So James has informed us that a dog is merely property in the eyes of the law, right? And so depending on the language, right, if there's like a date certain that he would have to return the dog, you would, I think, do it as any other enforcement for release of property.
So
Did you get it together? Come on. We're here on Facebook.
I know. My kid's locked out of the house. Should I just leave them there? You can figure it out, right?
Yeah, we're on Facebook. He doesn't have Facebook?
Oh my God. I was texting him. So sorry. He'll figure it out. Maybe if not, I'll be stepping away for
Right. I feel like you should step away at this point, because if someone from CPS may be listening to this.
No, I gave him some instructions on how to get in. So let's see how well he follows instructions.
Be food outside. Know your son.
The nanny too. So don't anybody call the authorities for someone. Okay, so this is just, I said creative lawyering, but I'm gonna say that maybe not so great. He made it in. He's in. We're good.
Perfect. You step on or what? No.
So I don't think that this was smart. This was not good lawyering. This was like actually potentially terrible lawyering. because you don't have any recourse for this. So it's kind of crappy, I think. And I understand it, but it's kind of frustrating from an attorney standpoint. So when it comes to property, if property is divided in a divorce decree and somebody doesn't comply with the provision of the property division, you cannot, in most circumstances, hold somebody in contempt of court for not complying with property provisions. There's rare exceptions. You're giving me ojos. I already see your ojos, but there's rare exceptions. And so why are you?
What is
Your eyes, you're giving me eyes like I'm not correct.
Wait, isn't that what it's called when you have to crack an egg on a child's head or something?
I don't think so. I think that's like they say like the child has ojo. I think.
Oh, okay. All right. I was like, I'm giving you a cracked egg. I didn't know what was going on. Got you. All right, go ahead.
Okay, so in most cases, if somebody doesn't comply with the division of property, you can't hold them in contempt of court. And so there's rare exceptions, like if the property or the cash was in existence at the time of the division, if they fail or refuse to turn over an item by a date certain. So it's very tricky on when you can potentially hold someone in contempt of court for violating a property division. Okay. And so in cases like this, where you have a money that is owed for any purpose, typically what we try to do is we try to secure it with a lien on the residence. And there's a triggering effect that says that if they don't make these payments in compliance with the order, if they don't make these payments, each month, or if they don't make a lump sum payment by a date certain, then at that point, the other party or the client would have the ability to go in, just like a creditor, and request that the residence be sold so that they can get their money back. Okay. I would presume that there was not like any sort of deed of trust or anything. Or a real estate lien note. Maybe they did a real estate lien note for the dog. But absent that, I don't know. I guess you can file a motion for enforcement and basically say, Judge, he didn't give me what he was supposed to give me, and so now I want the dog.
Well, so it's, and this is kind of where I was confused. So it sounds like that if he fails to make a payment, then he has to return the dog. I'm assuming it was drafted well, so by a date and time certain at a location certain, right?
That's a big assumption given the terms of settlement.
It is a big assumption, but I'm going to go with it. And so if that were the language and he failed to satisfy the condition preceding or whatever and make the payment, that sounded smart right there.
You did sound super smart.
Yeah. Are you Googling precedent? It means before.
No.
All right. So if you fail to satisfy it, then that would invoke the return of property, which was in existence at the time. So it's not like a debtor's type jail thing. It's, you got the dog, you're supposed to return it. If you fail to satisfy A, you didn't satisfy A, can you be held in contempt for that?
I don't think that he gets held in contempt. No way, no freaking how.
Okay.
I think it's not enforceable.
Why?
Because it's a property division. And so you're saying if it was drafted well and it incorporates language ordering him to produce an item at a date certain upon this condition.
Yeah.
And he doesn't.
Right.
Maybe. I would love to see this order.
I think it would be fun to litigate for sure.
I think I would kind of be annoyed with the idea of it, but I guess, yeah.
I've never litigated over a dog. I really want to.
I mean, I guess I just think that it's craziness. It's absolute craziness. But maybe a judge would hold him in contempt. I think more than likely it would just be you need to produce the dog or else I'm gonna do something, and then he has to produce the dog. And ultimately it sounds to me like that's what she wants. So I would not recommend that people do this though. No?
I
You don't-
mean, I guess it depends on how much the loan is and how much the dog's worth.
Yeah, maybe it was just like a small little loan, like a $500 loan or something like that. I don't know. How much is a dog worth? How much is your dog worth to you?
To me, or like how much I pay for, because they're two different things. To
How
me,
much is it worth to you?
10% of what I paid for them.
Okay, so next question. Let's just move on from the dog. Will it affect my divorce if my wife is on my car loan as a cosigner? My wife wants me off the car loan. Will it make my divorce be delayed?
No. All right, next question. No, it won't. Likely what will happen, generally what happens in decrees, is off the loan. So it's her car? Oh, no, his car, she co-signed. Okay. So likely what will happen is you'll have a certain amount of time after the divorce is granted to refinance the car to be solely in your name, removing her from any liability. And if you fail to do so, then you'll likely have to sell it. So it's not going to delay the divorce. You can still get divorced. You'll just have to refinance it at the end.
Judges don't always order the refinance of vehicles.
No, not always, but most of the time. I think there's exceptions when it's not required, but like if
Most of the time they refinance, I feel like it's just like some of the time that they order the refinance.
of vehicles,
Yes.
no, my experience is I think it's most of the time. Where's Sarabia? I know he agrees with me.
Yes, of course he does, always. I mean, I guess
You can't just go on tying up your ex-spouse's credit.
well, I understand that, but at least in a lot of the cases that we're dealing with, there's very little to no equity in the vehicles, and the cost of refinancing is very difficult. And so and sometimes they're upside down, they can't do it. And so in those particular cases, it's basically like, hey, everybody is just going to be responsible for making those payments. And then if you don't make the payment, then you can repossess the vehicle, or you have to sell it, or you have to do something like that. But vehicles are always kind of a sticky situation, at least for me.
Yeah, I don't really find it that complicated. I mean, I think that there's situations where, like, if you have a stay-at-home spouse that doesn't have credit, doesn't have money, that kind of thing, and it wouldn't be unable to refinance, right? In those circumstances, I don't think they're going to require it. But I can't think of a case where I've seen a judge just allow it to go on for years without being refinanced. I mean, I think what they would do if husband couldn't refinance is give it to wife and let wife deal with it, right?
Yeah. Okay. Well, yeah. So no, you can get divorced fairly quickly, even with that.
Yeah. Doesn't matter who's right. You can still get divorced.
Agree to disagree. Okay. Next question.
How to collect arrears. Where's Sarabia? That's a good joke in the waiting. My children's father owes $15,000, and every other month it keeps going up because he isn't paying, and hasn't been paying since last year when I finally filed for child support. I was granted back child support and monthly payments, but never received them. If I get a lawyer, will it be guaranteed that I will receive it?
Oh, the old guarantee.
Guarantee.
Yes. So no, it's not guaranteed that you're gonna, and nothing is guaranteed. And if ever you go and you visit a lawyer and a lawyer tells you, I will guarantee that this will happen, you need to get up and walk out as quickly as you possibly can, because we can't make guarantees. Even if we have an absolute brilliant case and all the facts line up and, you know, you're golden, it still doesn't mean that we win. I tell people all the time, litigation is scary. It's stressful. You never know what's going to happen when you walk into that courtroom. You don't know what evidence is going to be presented. You don't know, what the judge is going to feel about your particular issue, etc. So no, nothing is ever guaranteed when you get into litigation. What I will say is typically what we do in this situation is we will file a motion for enforcement. And we request that the judge put him in jail for up to 6 months, and basically hold him in contempt, request attorney's fees or reimbursement of attorney's fees, and having to file the motion for enforcement. And depending on the court, which is why we always recommend that you hire local counsel to whatever county you're in. Depending on the court, some judges, like first time, they put you in jail. Most judges, I would say, normally will put them on some sort of community supervision, which basically it's not like, probation in a criminal matter. It's if you pay your child support, if you pay your arrears and you do all that stuff in a timely manner, then you don't go to jail. But if you don't do that after you're placed on this community supervision, then the judge, well, let me back up. If he doesn't do that once he's placed on community supervision, then you would have to come back in, file a motion to revoke that community supervision. And then I would say, probably 8 times out of 10, the judges will put someone in jail for a certain amount of time just because they're obviously not getting the point of everything. And so typically what will happen is when you file this enforcement, the judge will again confirm the judgment, which it looks like already happened in this particular case. He'll confirm the judgment, and then he'll say, all right, your current child support is $600, right? Or whatever it is. So you got to pay your current child support, Dad. Plus I'm going to make you pay an extra $200 to get rid of the $15,000 that you owe Mom. Okay. And I'm going to put you on community supervision. You got to make sure that you're paying that $800 a month. As long as you do that, you don't go to jail. If you don't do that, then you get to go to jail up to 6 months and you have to pay attorney's fees. So I would definitely encourage you to do that, because if you don't, it's just going to continue and you're never going to be able to collect monthly support, and that's going to kind of suck. So you should at least start the process. See?
Yep. Only thing I would say is you can also register with the AG, like for full services, and they have collections and enforcement remedies available to them that we don't, right? Like they can take a tax return. I think they can do an administrative withholding or whatever to increase the withholding automatically, right? They can keep him from, renewing his driver's license, registering his vehicle, things like that would help you get some of the money.
Yeah, that's a good idea.
That's the only kind of ideas I have. Yeah.
Okay. Next question, please. My turn to read? My turn to read.
Yeah.
Okay. Domestic family violence. My wife called 911 and made a report. The officer took a picture of her neck with a small scratch and turned it into the detector. And turned it into the detective, I presume. Now later, she regrets calling 911. How can we stop this case from going forward?
If I had a nickel. So this is more of like a criminal question, and it is a family law question, so that's good, makes sense in that a little bit.
Mm-hmm.
So it depends, right? It depends on a lot of factors, right? Whether, okay, you don't have control of it. You can't decide whether it goes forward. She can't decide whether it goes forward. It's up to the state whether they want to prosecute. What it depends on is how good your attorney is, right? And what magic your attorney can work. And it depends on, you guys' history together and your history, if there's a history of family violence. Because what can happen is she can sign an affidavit of non-prosecution, affidavit of fact, that can be submitted to the prosecutor. And if it's kind of a weaker case and there hasn't been trouble before, prosecutors in their discretion may decide not to move forward with it. If they decide they want to move forward with it, well, then they move forward with it, and that's what it is. So there's nothing you can really do except hire an attorney and see if you can go about it that way, talking to the prosecutor, talking to the detective, depending whether it's up to the prosecutor's office at this point or not. Yeah, so that's pretty much it. Once it's investigated, it's done.
So do you find it interesting that he doesn't say, like, I didn't do anything to her neck? He just says, this is what happened, and now she wants to stop the case.
He wouldn't say that because it was turned into a detector, and the detector would know if you were lying.
Those damn detectors, they get you every time. Yeah, I mean, I agree with everything that you said. I have several thoughts on these types of situations, because unfortunately in family law, divorce proceedings and child custody proceedings, we see this type of stuff happen quite a bit, right? Where the police are called and maybe it's just an argument, maybe there's false allegations that are being made, maybe that, husband did in fact do something that he wasn't supposed to be doing. You have to be careful when you find yourself in these types of situations, because it has a tendency or a possibility of completely being taken out of your control, which is what Floyd's saying. And so, if in fact maybe wife made misrepresentations to the police, that's not going to be great. If in fact husband did in fact commit an act of family violence, that's not going to be great. And at the end of the day, especially when it comes to these family violence offenses, a lot of prosecutors will continue to proceed with a case even if the wife recants, because their position is a lot of times victims of family violence have a tendency to change their story and to say, no, this didn't happen, or I don't want to proceed. They keep going back to the violence, which, a lot of prosecutors just say, we don't care what she's saying now. We know what she said then, and we know what the photos show. And so we're going to go ahead and continue to prosecute this. And obviously that's not going to be good for your marriage. It's not going to be good for your kiddos. And so you have to be very, very mindful of all of the potential consequences. And obviously, if in fact things like this are happening, then you do need to call the police. You do need to get them involved, and you need to get yourself out of that situation as quick as possible, for your safety. And if you have kiddos, for your kiddos' safety. So I think Floyd's right. You need to hire an attorney. You need to have that attorney explain your particular situation. And hopefully the fact is that you didn't do anything. It was just an argument that got spun out of control, and maybe it doesn't go anywhere. So cool.
Cool.
My turn, your turn.
Family violence, it's my turn to read.
Okay.
If my child doesn't live with their mother, is she still eligible for child support? My kids live at their grandma's house.
Okay.
Period.
That's the fact pattern.
Okay. Go. You get a lot of assuming in this one. Just do with it what you will.
I love that very much so.
That's common. It's one damn question with all your fact patterns.
Is there an order in place? So let's assume that there is an order in place and mother pursuant to that order is eligible to receive support, but she is allowing the children to stay with grandma. Then the answer is yes, she's still eligible to receive the child support until potentially grandma, or I guess maybe even you as the father, try to modify it so that mom can't collect the child support. Okay. Let's say that mom is going to file an original suit, and in the original suit, she's requesting child support, but the children are living with her mother, I think that that's evidence that you could potentially present to the court. But if the grandmother's not involved in the case, I think mom still maybe gets child support and the discretion of the court. No? Yeah?
I mean,
Not involved.
yeah, if mom gets primary, I guess.
Right. And if she files an original suit, then grandma could potentially intervene. And if grandma intervened, then grandma had the kiddos for 6 months or more. Or if grandma could prove there was danger to the children, then maybe grandma gets primary and you're still, as the father, likely gonna have to pay child support. But in that case, so is mom. So, and if maybe the kiddos are with grandma, listen, you don't give me a question like this. I can go on for years.
Just skipped it.
So if the kids are living with grandma and if grandma's a danger, well, then that potentially opens the door for you to request a modification. And even if grandma's not a danger, you could request a modification to ask for the kiddos to come and live with you because mom's not taking care of them. And then you get child support.
Yeah, I guess it depends on how long the order's been effective. In fact, there is an order in effect, and whether you're requesting a temporary order or final, because burdens could be potentially different. Yeah.
If it's within a year, then you're gonna have to show significant impairment. This is a disaster. Keon, no more questions like this because we just go all over the place. So yeah, you need to talk to a lawyer. How about that? And tell them your particular situation and it'll all work out. So next question. My turn to read?
Yes.
Can I direct the court to perform a DNA test on a child in a different state? I met a woman in March 2004 in El Paso, Texas, while I was in the
Every
Army.
good story begins with I met a woman.
Yes. She never mentioned she was married. And in August 2004, she got pregnant with twins. Like soon after the babies were born, she revealed the truth. We did a quote unquote peace of mind DNA test because I do have the pertinent documents, got orders to deploy to Iraq, and I wanted to know who was the real father. It came back that I am the real father. However, she kept the secret from her husband. And I agreed to it just because of the uncertainties in Iraq. I would like to know if it is possible to place a motion in Texas to perform an official DNA test on them. I am currently located in the state of Florida.
Julie, jump on.
I know, Julie, where are you at? Lord. Go for it. I'm so glad that you got this question.
God, this is a nightmare. Okay.
You got this, Floyd. I have faith in you.
2004, it's now 2020. The kid's freaking 18. Why do you care? Done.
Next question.
Yeah, so it's been more than 4 years, I'm guessing. Well, so I guess it does really depend. Like if the child is 18, the child is not a minor anymore. And so, what?
There's two of them.
They were both born at the same time, right?
Yeah, but you keep saying child, it's children.
Oh, okay. Yeah, whatever.
Go.
Actually, they wouldn't be. So they met in March. I don't know how long it took her to get pregnant. Oh, August 2004. So August 2004, the kids would have been born May 2005.
Yeah.
All right, so you got about a year left. I think it's going to be very difficult.
Dude, the kids are 16. I didn't even get my calculator out because I suck at math.
No, kids are 17.
Oh, they're 17. It's 2022, not
And your calculator sucks too.
Not the calculator, it's my brain. I'm still living in 2021. So continue, my apologies. A year left.
Yeah. So they'll be 18 in 2023. About this time next year. All right, so
Why?
Why what?
Why would he want to do this?
I have no idea, but I was gonna go through the analysis.
Okay, go ahead.
At least I think, I'm probably gonna screw it up because this is difficult, but.
Okay.
All right, so husband's presumed father. I think husband could bring the case because husband doesn't know. He could allege fraud and bring the case. Bio dad cannot, because bio dad knew that he was the father the entire time and did not request a genetic test within the 4-year statute of limitations. So, well, his question is, what's the question? Is it possible to place a motion in Texas? Yes, you can place a motion.
Will it be granted? Probably not.
Yeah, probably not. Actually, there's factors that they look at.
So I feel like we should pump the brakes on this question.
Yeah, I agree.
You know?
I was trying to tread carefully.
And the reason is we have an active, like this is something that's going on. Yeah. And so I feel like we got to kind of just pump the brakes. And once those cases are done, we can come back to it and we can answer the question.
But let's talk about the why. We can do that. So why in the hell would you want to do this when they're 17? By the time you got the motion filed, got it heard, got the testing back, all that would happen is you pay child support for 6 months, right? I mean.
Well, and then honestly, like that, it makes me nervous for the retro support. I mean, if he knew that this was his kiddo and he like just bounced for 17 years and then's coming back in, I think they could say, we want you to pay all this back support. So, and not to mention like the issues with the kids at that point, like that's crazy. So yeah,
Why after 17 years do you even want to know?
He knows though. That's the thing that's weird about it is he did a peace of mind DNA test and he is the real father. He knew he was the real father when they were itty bitty.
Well, he wasn't deployed for 17 years.
Right. But what I'm saying is if they did the DNA test and then he goes into court and he says, well, I did this DNA test, 17 years ago or 15, 16, whatever it was years ago. And so I know that these kiddos are mine. Then the judge would say, okay, well,
pay up.
Exactly.
Yeah.
Yeah. But we do, I mean, it's an interesting fact pattern. And I do see that like happening quite a bit. And it's something we need to talk about eventually, but just not today, my friend. So.
Okay, so if a green card holder leaves the marriage, how can the affidavit of support be removed? The spouse left, you don't know what that is, do you? It's an immigration question. The spouse left once his kids were approved for a visa. When the spouse returned to the US and continued to live on his own with his kids, he wants me to pay him spouse support and child support for his kids.
I have no idea what's happening here. You understand it?
My understanding is whenever someone comes over, when you assist somebody in coming over, sign off on a visa or whatever, you do an affidavit of support saying that you will be responsible for their support and not the government, right? And I guess she doesn't want to do that anymore since he left her. And so she wants to know whether she can remove the affidavit of support so she's no longer obligated to support him.
Ah, okay. So the spouse returned. So I guess he had left, and then when he came back under the visa, then he bounced and he went, okay, I got you. So do you know the answer to this? Because I do not.
Yes, I do.
Go for it.
No, can't.
So.
Like Chuck.
So she can't remove the affidavit of support through immigration, but I'm suspecting that he's also filed a petition for divorce. And in that petition for divorce, he's requesting spousal support and child support. Yeah,
Maybe it doesn't say anything about that, but we can go with it.
it says he wants me to pay him spousal support and child support for his kids.
His kids, not our kids.
Okay. So is she gonna have to do that?
I don't think so. I don't know a lot about this. I know very little, but I think basically you just have to, if they get on government assistance or something like that, you would have to reimburse the state. That's my understanding, but you can't remove it. Like once you sign for the visa, you're responsible. You can go to his next hearing and try to get his visa taken away, claiming fraudulent use of the marriage or whatever. So, yeah, okay. Next question.
So,
Oh, go ahead. Do you have a question?
no, am I supposed to read or you're supposed to read?
You didn't answer that question. Would you like to answer one or no? You want to just go with?
I think you're doing a great job today, Floyd. So why don't you just continue?
How do I apply for my daughter's passport if my husband refuses to cooperate? I'm going through a horrible divorce. All divorces are horrible, man. I have signed temporary order that states to both of us, states that we are both joint managing conservators, that we have an obligation to apply for and renew our daughter's passport. I'm also the custodial parent. I reached out to him on 3 separate occasions via text and email that I need his help to apply for her new passport. He fails to cooperate effectively, co-parent effectively, but he's holding up the passport process. How do I go about applying for her passport without dealing with him?
So this is where drafting is so very important. And it's important that attorneys know these provisions. They know what's important to clients. So at our office, when we approve any orders, we always have a meeting with the clients and we go over those orders with the client, right? And so the standard like passport language basically just gives each one of you guys the right to apply for a passport, right? That's now been incorporated into the rights and duties. But there is more extensive language that you can also incorporate in your order that says, can I just say that I'm happy that I finally know an answer to a question? I'm just gonna.
Well, I really think you're about to mess it up, but go ahead.
What do you mean? No, let me keep going. I'm gonna.
I said, go ahead.
Okay, so there is more extensive language that you can incorporate into your orders that states that each one of you guys, and you can switch it up. You can say that each one of you guys have the ability to apply for a passport. You can say mom has the ability and dad has to sign any documents, or dad and mom both need to appear at a date certain to get the passport. And then there'll also be additional language that says that one parent will have the exclusive right to hold or to maintain the passport subject to exchange provisions. And basically, like dad would have to give mom notice of, hey, I'm going to, go outside of the country. Typically, it's a 21-day advance written notice, and then mom has to give him that passport 10 days before he leaves. And then when he gets back, he has to give it back to mom, right? And so there's really some very specific language that you can incorporate when it comes to passports. And, as far as the signing of documents, you can state that he has to sign within so many days. I mean, they're ordered, you're both ordered to fill that out. If he, am I still screwing it up? You're checking and you're realizing that I'm right. So I shall continue.
I'm checking, but I think you're wrong. You want me to tell you what I think you're wrong on?
Yes.
We'll check and see if I'm right. So I think the new standard language for passport, it includes just that one paragraph about the 10 days. It doesn't include all the other stuff that you're talking about, but it does say that, I think it says that they both have the independent right to apply for, renew the passport, and the other parent has 10 days that they apply for it.
See, I didn't think that it had the 10 days. I thought it just had like that one line under rights and duties that says that they have the right. Is it subject to the agreement of the other conservator, or it can be independent too, to
Yeah,
apply
it's
for the
independent.
passport?
It's independent. But I
So-
don't know whether that one, I think that one paragraph's in there, but I'm not sure. I'm looking.
Okay, so if passports are important to you, it's important that you talk to your attorney about that extensive language and that you actually address that in court, like who has the right to maintain it, what's going to be the requirements for exchanging, etc., who's going to pay for it. You can really kind of dive deep into this passport language. So it says here that both of us have an obligation to apply for and renew our daughter's passport. I'm going to go ahead and just assume that it doesn't have all the 10-day requirements, because if so, I think that it would have incorporated, or should have incorporated that in her question. And so what I would recommend that you do is file a motion for additional temporary orders, or to modify the temporary orders to request that more specific language. So that way, if he's not going to comply and if he's not going to do what the judge orders him to do, you'll have the ability to hold him in contempt of court. And so what I will say is that I had a case where our client had been deployed. He was in the military and he was in Germany, and he had the right to summer visitation, 42 days in the summer. And so he had and the little boys, there were twin boys, and they were probably like 4 years old at the time. And so dad contacts mom and says, hey, I want these kiddos to come with me to Germany for the summer. We need to get the passports. You know, here's everything I've submitted. Here's everything that I paid. And mom was basically like, F you, I'm not going to get this passport because I don't want my kids to go to Germany. And didn't request a modification, didn't request anything. And so we go to court and need to enforce the passport provision that we had in our decree. And needless to say, judge was not very pleased with her. She had to pay attorney's fees. And at that particular time, I think we'd already encroached into the summer visitation. And so dad ended up giving, or judge ended up giving dad like 60 or 70 days worth of summer visitation, kind of as a punishment to mom for withholding the application for the passport. So, and I want to say, doesn't the language state like they have to cooperate unless there's a reasonable basis for not complying with the passport request, Floyd?
I've never seen an exception like that I can think of.
I think that there's something, if it may be in the exchange language, like when they have the passport, and that they shall, that's what it is. It's the 21 days notice of, hey, I'm going to be traveling to, and we had another case where the wife wanted to go, or the mother wanted to go to like somewhere crazy like Iraq. And she gave the dad the 21 days advance written notice. And we had to go in and we had to file a temporary restraining order requesting an injunction so that we didn't have to turn over that passport, because our client was concerned about the children's safety. And that's why typically the language is the 21 days notice, because if you are concerned about the safety, you have time to go in and try to stop it. And so I think that you can withhold it if there's a reasonable basis, but you better make damn sure that it is in fact reasonable. And the safer bet is to do what we did and file that TRO and get it in front of the judge, and then let the judge say, like, no, you're not taking the kiddos to this place. Like
Yes, the standard language doesn't require that notice to travel, right? That's the extended language.
Mhm.
I haven't found it yet, so we'll go on and we'll come back to it if I find it.
I think what you're saying is that I'm probably right, and you just are not going to concede that I'm right.
You must be having trouble with your ears today.
Okay, very good. My turn to read. So husband and wife are splitting and getting a separation agreement, splitting assets / liabilities with a plan of a future divorce. If the husband, for example, was in an accident without enough insurance and was being sued, could the wife's assets or job money be taken if the husband loses the lawsuit?
This is more like a civil question. I think it is. I think it could be. So we don't recognize separation agreements. You're married until you're divorced. And so I think certainly the community assets, right? Could be, what's the word? Not liable, that's not the word. Could be.
I know what you're trying to
Take
say.
it, whatever, right? So yes, community assets. I don't think anything that's associated with her separate property, you know, if she has separate property funds or whatever, I don't think they could attach to that. But certainly community funds, they would be able to, because we don't recognize separation agreements.
I kind of feel like they're trying to pull some funny business, right? Like, hey, well, we're going to do a separation agreement because he's about to get sued and we're scared. And so, yeah, you just need to get a divorce and then just live together. So.
Well, but even then, if the accident's already happened, then the complainant in the accident would intervene into the divorce with a claim to the community assets, and you get problems there.
Yeah. Yeah, and if they have assets, then they're, yeah, that's not going to go over well. So, yeah, you can't do that. So, next question, final question. We're going to end early today. Go, Floyd.
Oh, okay. Sorry, I'm researching.
Please, Lord.
What is the possibility of getting sole custody?
Oh, wait, can we just stop really quickly because there's a comment that I would like to highlight. Josh's answer doesn't count because he's reading. Ms. Jimenez doesn't read. She knows.
I'm trying to find one thing that you've said on here that you would have known.
The passport thing I knew.
If you're right on it.
The domestic family violence thing I knew. The grandma
question.
But I knew it. And
the
question I knew, and the arrears question. Get the hell out of here. I knew a lot of stuff. I know a lot of stuff. It's all in here.
You had it right the first time.
Okay, go ahead. My turn to read or yours?
Mine. We'll see if you know the answer to the question.
Don't put this pressure on me, Floyd. Lord.
My husband had assaulted me while I was 3 months pregnant and left the home with all my passports. I have filed a complaint after the baby is born and filed for divorce. He's asking for child custody, and the DV case is still pending. Divorce case is still pending. Charges are not filed yet, as I have filed the case late. What are the chances of me getting sole custody because my husband is just using the baby as a tool?
A tool?
Tool.
So there's so many ways to go with this. Do you hear my son?
Yeah, I guess he's in. We have proof.
Yes, he's in. Okay, so if you are a victim of family violence, don't wait to file a police report months later. And the reason is that it affects your credibility with the police, and it affects your credibility with the court. And they're going to have, it increases the likelihood that they may or may not, or that they may not believe that the incident actually occurred, right? And so now after the baby's born, and now after the father is trying to take you to court for sole custody, now you have filed a complaint with the police department alleging that this incident happened, you now potentially, or it could be perceived, right, that you have motive to not tell the truth, right? Because you're afraid that you're going to lose custody of your kiddo. And so what should have happened is when you were pregnant, should have filed the police report. If you didn't, or obviously you didn't, then hopefully you have some sort of evidence to actually show that it occurred, right? So photos, videos, text messages, emails, any sort of documentation to prove that that actually occurred. And then that would increase the likelihood that the police will prosecute, and it will also increase the likelihood that a court will believe that you are in fact a victim of family violence. And the presumption is if there's a history or pattern of family violence, that you should be appointed as a sole managing conservator, right? So we don't know how old this kiddo is, which is another big factor.
Oh, so she said she just had the baby, then filed for, after the baby was born, she filed for divorce, so not too old.
Okay, so I mean, if we're assuming that baby's just a few months old, I think that what also is going to potentially be relevant is, have you allowed the father to have access to this kiddo after the baby was born and after this alleged family violence incident occurred? Did you stay with the father after this alleged family violence occurred, right? Because again, what the courts are going to be looking at is your credibility. And so if you're alleging, okay, this happened when I was 3 months pregnant, I didn't file for the divorce, I don't have any other supporting evidence or supporting documents, and then now that the baby's born, I'm filing for divorce, it's just going to be really, really tough. And if you stayed with him, if you allowed him to have unsupervised access to the child, getting a judge to maybe believe that is going to be tough. And getting a judge to award you sole managing conservatorship is also going to be really tough if those things have happened. What do you think, Floyd?
I think that, first of all, I hate this question because I hate sole custody, because sole custody means different things to everybody. To us, it means sole managing conservatorship, right?
Right.
But to the common folk, I don't think that means that sometimes.
Well, why don't you explain what the difference is?
So sole managing conservatorship, basically the way I break it down is, when you're dealing with conservatorship, which are the rights of parents, rights and duties of parents, you have joint managing conservatorship. So the rights are broken up in basically two different sections. First is the information rights, so a party's right to receive information, and second is the decision-making rights. There's a couple more, but for today's sake, we'll go with those two. And so under joint managing conservatorship, you both have all of the rights, the information rights and the decision-making rights, except that generally one party will have a decision-making right that the other one doesn't have, and that's the exclusive right to designate the primary residence, which means the child lives with them. If you have a sole managing conservator and a possessory conservatorship situation, then the sole managing would have all the information rights and the decision-making rights, and the possessory would only have the rights to receive information, but not to make any decisions. But that's actually required if she can prove the family violence, even if she's allowed visitation.
Well, I think the key difference is, and where people oftentimes get confused, where they say, I want sole custody. Really what they're saying is they don't want dad to have visitation, right? Like they don't want dad to see the kiddo, right? They don't really care, or most people don't know about the information and decision-making rights. They're more concerned about, do I have to let the kiddo go with dad, right? And so even if you're appointed as a sole managing conservator, dad can still have visitation, like regular visitation, weekend visitation, 50-50, like whatever the heck. If the court finds that that visitation is not going to endanger your kiddo because of a history or pattern of family violence, then that could happen. So, and I would say, if one incident that happened, assuming that it was just the one, and I'm going to go out on a limb and say it was just the one, assuming that that's the only thing that happened, I don't think it's a good case for sole managing at all. It depends on the evidence, right? If there's photos, if there's videos or whatever.
If there is an act of family violence within 2 years, it's mandatory.
If she can prove it.
Right, yeah. If she can prove that he assaulted her, then it's mandatory assault.
Correct. And that's my issue is that it was so long ago and she didn't file a report. It's just, and these are the types of cases where you have to look at everything, right? You want to look at the text messages, you want to look at the photos, you want to look to see if there were witnesses that she called immediately after. Like there's ways that you can add credibility to the alleged family violence incident. But if you don't have those things, I think it's really, really going to be tough.
Or a good one is him texting her later apologizing for assaulting her. Those are fine.
Yeah. And that's what I'm saying. You're going to want or need something like that. And again, were you with him? Did you allow visitation? Like all that crap is going to come into play. And I'll say, like, a lot of times, if it's one of these situations where the evidence is very, potentially weak, and it was a long time ago and all that stuff, a lot of times judges aren't inclined to grant sole managing. They're not inclined to limit visitation. Those are tough cases. And so that's why it's important that when these things happen, that you do call the police, that you do report it, because, it needs to be documented. So.
All right, before we shut down, I just want to let you know I was right. So I did a quick draft thing.
You were drafting like while we were talking?
Yeah, when Maria was accusing me of reading and researching, I pulled up a pleading and did a quick little draft.
Okay.
And it does say, if a party applies for a passport for the child, that party is ordered to notify the other party of that fact no later than blank days after the application. It is ordered that if a parent's consent is required for the issuance of the passport, that parent shall provide that consent in writing no later than blank days after receipt of consent documents, unless the parent has good cause for withholding that consent.
I don't blame you. Someday.
Maria, I couldn't hear you. What were you saying? Okay.
Well, with that being said,
a little silent on the comments right now.
Oh my God, Floyd, you're so annoying. And I'm going to go back and I'm going to check that. I was going to start to draft my own, but conveniently we only have a minute left. Floyd.
You want me to share my screen with the crowd?
No, because you get to select what you select when you're drafting. I'm going to have to look it up in the Family Law Practice Manual and prove you wrong. So like we say, beginning, middle, and end of this event, don't accept this as legal advice. If you find yourself in this particular situation, I want you to make sure that you reach out to a really good attorney, somebody that you're comfortable with, somebody that practices in the area where your case is located, and follow their advice. Be honest with them, tell them the entire story, good, bad, or indifferent, and make sure that you listen to what they tell you. And anything that we share on this podcast, on this event, it's basically just an opportunity for us to talk through complex legal issues, and for us to basically disagree with one another for an hour. And then after that, you guys need to go and consult and maybe share what you've heard, and then the attorney can tell you whether or not it's going to be applicable to your case. And so with that, Have a happy Friday, and Floyd, I'll be sending you an email here in a second when I prove that you're wrong. So
Awesome. I look forward to it.